Hello, welcome to the study of criminal law for paralegal counselors. This is your host, Dr. Tulipo Mwenifumbo. Today we are going to look at the distinction between criminal law and civil law. As we may know that there are two different types of jurisdiction. There is what is called civil jurisdiction and also what is called criminal jurisdiction. So in all the cases are categorized in these two jurisdiction. So now, what is a distinction between a criminal law and the civil law? Basically, civil law regulates the private rights of individuals, whilst criminal law regulates individuals' conduct to protect the public. So now what we have to know is that the civil law has to do with private rights of individuals and institutions, whilst the criminal law has to deal with individual conduct to protect the public. So those are the two things that we have to know about the civil and the criminal jurisdiction. So civil jurisdiction or civil litigation is a legal action between individuals to resolve a civil dispute. So the civil litigation, it is whereby two people have failed to understand or have failed to conclude or have failed to resolve their disputes. So when the two people or two institutions fails to resolve their disputes and they need now someone to mediate, which is the court, and that is what is called civil litigation. So if someone is offended by another person and sees that this person has unfairly treated me, so that becomes and this person goes to court for issues that has to do with the person, an individual. Now, also like criminal offenses has to do with individuals, but now it's the criminal offense, the distinction between criminal offense and the civil litigation. There, as we said, that the civil litigation has to do with civil disputes, but the criminal jurisdiction has to do with prosecution. This is whereby the government prosecutes a defendant to punish illegal conduct. So the criminal jurisdiction has to do with the conduct of an individual, which results into this person being punished for doing a wrong thing, or something that is not acceptable, or that is something that is not acceptable in that particular society, or what has been regulated as not acceptable. So basically, criminal law deals with the behavior that can be termed as offense against the public, society, or the nation. Even if the immediate victim is an individual, the criminal offense deals with the state. It is, you have done a wrong against the state, against the people, against the society. For example, assault, theft, and doing other things that may injure directly an individual or a society. So basically, criminal offenses has to deal with the things that are forbidden to do. So something that the society and it has been enshrined in the books of law that this thing should not be done. So now, if you do that thing which is not supposed to be done, it is that becomes a criminal offense. So criminal offense deals with the things that have been forbidden by law not to do. So anything that you are not supposed to do by law, it can result into the criminal offense. Now, it's not only the things that you have been told not to do, but also not doing what you are supposed to do. I'll give you an example, like in the most of these administrative laws. Administrative laws has much to the most of them, they can result into criminal offense. For example, you are supposed to pay tax and you are not paying tax, then it can be a criminal offense. So where there is a written law which states that you are obligated to do this and you don't do that, then it becomes a criminal offense. And also where the law states that you are not supposed to do this and then you do that thing, so that is also a criminal offense. So the other thing that we have to know about the difference between criminal law and the civil law. So civil law deals also with behavior that constitutes an injury to an individual or the private part, such as a corporation. Examples of civil jurisdiction, it can be defamation, slander, breach of contract, negligence, resulting into injury or death and property damage. So these can be cases that can be considered as criminal cases. So as the civil cases, where there is an injury on an individual which results into loss or it results into disturbance. So that is those cases are in a criminal jurisdiction, and in the civil jurisdiction. So the criminal law and civil law differ with respect to how cases are initiated. Number one, there is who may bring charges or file the suit. So in the civil jurisdiction, an injured person is the one who takes the case to court. Whilst in the criminal jurisdiction, it is the state that takes the case to court. Then in the what kind of punishment or penalty may be imposed, that is also the thing that distinguishes the criminal and the civil offense. Now, in the criminal offense, the offender is punished or given the penalty, may be imprisoned or pay a fine or do the civil work and other things. Whilst in the civil jurisdiction, the person must be he pays the other party. So the other thing is that in the civil jurisdiction, when the court is deciding, it decides at least where they see that there are possibility of this person doing this 55%. And once the criminal jurisdiction, they say it has to be beyond reasonable doubt. Why is it that the criminal jurisdiction is more stiff when it comes to judgment? It because of what is involved, because of the because of the penalty that is imposed on a person that has committed a crime, because it may require imprisonment. It may even go to death penalty if it is murder. So because of those issues, then it has to be beyond reasonable doubt. And when they say beyond reasonable doubt, they say that there must be not less than 95% possibility that this person committed the crime. Now, if there is a doubt of more than 5% that maybe this person did not do this crime, then that person must be acquitted according to what the criminal jurisdiction states. The other thing that we have to know about the criminal and the civil jurisdiction is how the cases are taken. Now, in the criminal jurisdiction, the first thing is that when the action is identified and of which the government has said that the people like the law enforcement officers, maybe let's say the police, will be able to identify it, or somebody is going to report that criminal suspect, and this person is caught or he's detained, and after that he is given what is called the charge. Now, so now that in the criminal offense, it is not an individual who is a complainant that can take that who can charge that person. Then the government has set what they call the prosecution. So the prosecution are going to give the charge to this person, and they are going to bring this person to take this person to court for the action which they consider to be criminal. Now, this action has to be well outlined in the criminal procedure or in the penal code. It must be something that is a written law. So now that is when now this person is prosecuted and is brought before court. Now, it is also the duty of the prosecution to prove that this person committed the crime. And it is not the person that is accused to have been committed a crime to prove, or not to prove that he has committed a crime. It is the prosecution that should give the proofs on how this person committed a crime. Then from there is the term that is used as guilty. Now, in the civil jurisdiction, there is this person feels offended, which is by the action of another person. For example, trespass. So trespass is not a prosecution. It's not a criminal offense. Maybe someone passes through your yard, then you are offended because of that. So you are going to say, no, this person is not supposed to pass through the yard. So you are injured by him passing through the yard. Then you are going to take the case not to the law enforcement officers, but you take the case you yourself to the court, and you have to hire the lawyers, or you have to represent yourself. But in the criminal offense, the defendant or the complainant who becomes the state witness is represented by what is called the prosecution. The prosecutions are the state lawyers. So he is going to be prosecuted as in the criminal offense, whilst in the civil offense you have to take the case by yourself, and you have to go to court by yourself. Now, there is also the term guilty and reliable. So in the civil jurisdiction, you are not guilty of a misdeed. But in the criminal offense, you are guilty. You are called guilty, but in the civil jurisdiction, you are liable. Now, in the civil jurisdiction, you should there is what you should you should be convicted. You should there is what is called conviction. So that is where now there is the proofs have been beyond reasonable doubt. So that is the major difference between the criminal offense and also the civil offense. So I hope that we have learned and we know the distinction. So in summary, we are saying that the civil jurisdiction or civil case is someone injuring an individual, whilst the criminal offense, it is one injuring the community. Then the penalties in the criminal offense is imprisonment, fine, and maybe given you have to perform a certain task by the government. It's punishable. Whilst the civil or jurisdiction is whereby now you have to compensate. There is compensation, and also in the civil jurisdiction it is compensation. Whilst in the criminal jurisdiction it is punishment. Thank you so much. I hope we have learned on the distinction between the criminal offense and also the civil offense. Remember, the criminal offense, nobody should be detained, or nobody should be detained in the civil offense, and no one can be imprisoned in the civil cases.